Aloha and welcome to Condo Insider. This is our weekly show every Thursday at 3 p.m. talking about primarily condo living, but association living. And it's designed to help not only board members, but owners and maybe even property managers understand what's going on in the industry. I know some of you, and I hope you're all well, by the way, with the COVID thing going on. And here we are in isolation again for another 2 weeks, but I hope everybody is well. And so you have plenty of time to not only watch Condo Insider, but all the YouTube, the prior shows to get a real expert on all of this. But anyway, we all know that early on in the COVID crisis, our legislature adjourned and then came back in session to finish up some housekeeping matters, mostly the budget and things along that line. And so most people think that nothing happened in condo world. When the legislature adjourned, we had approximately 8 bills that affect condos that were still alive. And then we went and adjourned and the legislature came back. And of that, believe it or not, several bills were passed that affect condos. And we're going to talk about 4 of them today. And we'll talk about a recent Supreme Court ruling on another matter for our kind of update on everything today. I've invited a really top-notch lawyer, a good friend of mine, one of the gurus of our industry and condo world, attorney Phil Nerney, to join us today. He's also the volunteer and the chair of the CAI Community Association Institute Legislative Action Committee. He's been doing this for quite a number of years. So welcome to the show, Phil. And why don't you begin by just briefly telling us a little about you and your firm?
Oh, thank you, Richard. I've been representing associations on a full-time basis since 1990, and I represent condos, planned community associations, and here and there cooperatives. So I've been at it a while.
And I think you would agree that the industry organization for condos is called Community Association Institute. And as CAI out of Virginia, their headquarters, they appoint a legislative action committee for the various states, which is Hawaii. And you're the chair of the CAI committee here in Hawaii. And can you just tell everybody a little bit about the makeup and what the CAI LAC does?
Of course. The Legislative Action Committee seeks to engage with policymakers on matters of concern to the association community, broadly speaking. There are many forces and perspectives on what the law and public policy relating to association living should be. Condominiums in particular are creatures of statute, which means that the legislature has a great deal to say about them. And sometimes the legislature gets complaints. We seek to address what the concerns may be and to adjust any public policy issues that arise from it. So basically, we seek to have input on public policy matters as relates to laws that affect condominium and other community associations.
I think it's important for the audience to know that the makeup of the committee isn't just property managers or lawyers. It consists of homeowners as well as vendors like insurance carriers and people like that that are also equally affected by public policy. So it's a broad-based committee with a lot of different views and interests being represented by the LAC committee.
I agree, that's true.
So anyway, as I said, there's quite a few bills that were passed. We can't and don't have the time to go into all of them today, but there are a couple that brought my attention. The first one I want to talk about was the original bill, Senate Bill 2421, which basically had to do with Act 195. And I'm going to ask you to tell our audience what Act 195 was and what did this bill do? Because it was, I should mention this to the audience, the 4 bills we're going to talk all passed, all were enrolled to the governor, and none of them appear on the veto list. So it is likely they will, with or without his signature, become law. So anyway, back to Senate Bill 2421 and Act 195. Kind of share what happened.
I will. First of all, Senate Bill 2421 just removed a sunset provision, which was part of Act 195. Act 195 made a number of changes that I will detail, but that law was set to expire June 30, 2020. And the real takeaway of Senate Bill 2421 is nothing changes this year. Act 195, though, made really significant changes, not all to industry's liking, but in a way that was adjusted to. And it related, broadly speaking, to partly to non-judicial foreclosures and processes relating to non-judicial foreclosure payment plans. And then the other part related to changing the scope of the pay first, dispute later provision under condominium law. Now it is only common expenses defined, I think most easily as, think of it as maintenance fees that are within the pay first, dispute later provision. Under Act 195, the legislature allowed people to dispute other charges, late fees, fines, legal fees, and to demand mediation in relationship to those charges. Those changes remain in effect. I should mention that it also prohibited priority of payment plans, which threw everyone for a loop. In 2019, though, there was a fix, more or less, on priority of payment plans. So Act 195 had prohibited them, but in 2019, there was a fix. Most of Act 195, therefore, is still in effect, although there is a change via 2019 legislation for priority of payment plans, or policies, excuse me.
And so SB 2421 basically eliminated the sunset date where all those changes back in 2018 and 2019 were going to go away. It basically made them permanent, is what you're saying. And
that's correct.
That's an easy way to look at it. And the basic fundamental thing for me on Act 195 was that these non-common expenses like maintenance fees and things along that line, pay first, dispute later applies. But those things like fines and legal fees related to fines, there's now a process of mediation to give an owner a chance to dispute those charges before they become permanent.
Correct.
Okay. So anyway, that's kind of SB 2421. I know very similar to that is SB 2425 that affected Act 196. Of course, Act 196 is a whole different issue than priority of payment. Can you tell us about, again, what happened under SB 2425?
Well, same thing, removal of a sunset provision. So for all anyone would notice, there is no effective change. Had Senate Bill 2425 not passed, there would have been a very substantial change. If we go back to what Act 196 did in 2018, it completely rewrote the mediation statute in the condominium law, much to the better. It also enabled a subsidy from the Condominium Education Trust Fund for voluntary binding arbitration. So, as you of course know, Richard, we lobbied to create a fund to subsidize mediation so that it would have greater buy-in and have a higher level of expertise on the part of the mediators doing the work. That is all preserved because Senate Bill 2425 passed.
Very briefly, because I know we have a limited time, what's your experience with Act 196 as far as this mediation? Have you found it to be kind of successful, working okay, or?
Absolutely. I do mediation work as well as practicing law. And it has created greater access to high quality mediation. And particularly, the change is now that there's more an evaluative model, because a lot of the mediators are retired judges or people with industry expertise. So when the parties go in, they can have the benefit of somebody who's mediating, who also understands the legal issues and just the contextual issues in which the disputes arise. So it has helped a great deal.
My experience has been that having the evaluative mediation model, particularly with some of the retired judges, they almost become like settlement conference judges. They can tell you really what they think and how they feel and try to encourage a settlement based on the law and their experience. And the good news is it's subsidized by the Real Estate Commission Trust Fund. So you can get in the door for about $175 a party and get through this process. So I've been very pleased with the results, although it only takes two people to agree at the end of the day, unless they do the binding arbitration model. So anyway, going on to the third room was Senate Bill 2871, which had to do with the fees, these biennial fees that all condo associations pay to the Real Estate Commission to fund not only dispute resolution, but education for board members. And what happened with that?
Well, the legislature recognized that way too much money is being collected. And so the Real Estate Commission is now empowered to adjust that fee so that it doesn't just keep accruing too much money.
So essentially, because the condos pay a fee every other year, last time I looked, I want to say there's around $2 million in that fund. Don't hold me to the exact number, but it's a lot of money, close to that if it's not used, why keep collecting the money? It gives the Real Estate Commission the power to say, okay, the fund's solid right now. We're not going to collect this biennium. We're only going to collect half, whatever it may be. And that's how I read the bill. Is that how you see it?
Yes. I know we're coming up on a break, but I do want to mention that the fee was set arbitrarily, and consequently, because we wanted the bill to pass when it came up, we didn't argue about the fee, although we did declare that it was too much money. Now is the point at time where we adjust, and I hope the Real Estate Commission will bring the fee down at the next biennial registration.
Yeah, so we've discussed 3 of the 4 bills. So what we're going to do is take a short 1-minute break, and then we're going to come back and discuss a foreclosure bill that was passed, followed by a recent Supreme Court ruling on foreclosure. Then we'll talk about that to kind of wrap up the show. So we'll be right back in 1 minute with Phil Nerney and Richard Emery. Welcome back to Condo Insider. I'm Richard Emery, your host of today's show. We're with Phil Nerney, a prominent local attorney on condo matters and chair of the Legislative Action Committee, talking about how the 2020 legislature wrapped up. In the first part of the show, we talked about 3 bills that really keep the status quo because two of them removed the sunset date. And so the bills can continue in force as originally written. And one had to do with the fees condos pay, where they might get a little bit of a reduction. And we said we're going to go into this half the show on foreclosures. And there was one bill, Senate Bill 3119, that had some impact on condo foreclosures. Tell us what that was all about.
Well, more of a clarification than anything else, but non-judicial foreclosures, which will be our next topic and are therefore something to be footnoted, had limits on use with respect to military personnel. And now it's clarified that if the delinquency has existed longer than 1 year, that the non-judicial foreclosure remedy is at least theoretically available to a condominium association. When we turn to the next subject, I can explain why it's theoretical.
Okay, well, let's move on to that, because, one of the big things that we've had seminars forever was the validity or legality of a non-judicial foreclosure. And there were owners who were delinquent, who were foreclosed upon and lost their home, and they've filed suits to try to recover, saying that the way I would look at it is the association didn't have the right to foreclose because the power of sale opportunity was not in their governing documents, would be a short way I would discuss it. Why don't you give everybody a better explanation than I just did on what the whole issue is and what the Supreme Court ruled?
I think you aptly summarized it. There was a perspective, certainly at the legislature, that the legislature had specifically authorized condominium associations to use non-judicial foreclosure as a collection or enforcement remedy to foreclose a lien, certainly, if there was a delinquency. Some owners challenged that, and as it worked its way through the courts, the Intermediate Court of Appeals issued a decision in a case called Sakal, where the Intermediate Court of Appeals concluded and held that unless a condominium association has in its governing documents or in some other agreement with an owner that it has what's called a power of sale, then it is not entitled to use a non-judicial foreclosure remedy, even though the legislature said that a condo association could. Well, there was also similar litigation in the United States District Court for the District of Hawaii, and one judge there held to similar effect. So where that left us was that the legislature enacted a law last year to say the legislature intended condominium associations to be able to use a non-judicial foreclosure remedy based on statute, regardless of whether they had a power of sale provision in their project documents. The Supreme Court of Hawaii took up another case called Malabe and held that the Intermediate Court of Appeals got it right in the Sakal case, and that what the legislature enacted in 2019 didn't apply, at least to that case. I think those reasons are more technical than we have time to delve, but where it leaves things is that according to both the United States District Court of for the District of Hawaii and the Supreme Court of Hawaii, an association, a condo association, needs a power of sale provision in either its declaration, bylaws, or in some other contract with an owner to be able to use a non-judicial foreclosure remedy. And at that, it does seem like there's a certain amount of judicial or appellate judicial hostility to the whole notion of non-judicial foreclosure. So Act 282, which was last year's effort by the legislature to express what it had intended, has not received particularly favorable treatment in the courts. In the Malabe decision, the Supreme Court of Hawaii said, well, we don't really need to decide about it, but they noted that the U.S. District Court held it to be unconstitutional as a violation of the Contracts Clause of the United States Constitution. Coming into the 2021 session, I expect and hope that the legislature may look at the whole question again and see what the available options are, and I expect that to occur.
So we know that the ruling has come out. What are you seeing in the marketplace? Are there a lot of lawsuits against associations now for improper use of the non-judicial foreclosure? Is this a big issue or a little issue in the industry?
Well, I haven't done a count. What I would say is this: the law changed significantly in 2011 and 2012. There was a moratorium on non-judicial foreclosures in 2011, and the law was completely restructured in 2012. So most of the cases that exist relate to old cases, things that were done prior to 2011. So a number of those cases by this point in time should be relatively few.
Well, I know that a lot of you see associations using non-judicials now, or are they pretty much shying away from it?
Well, I shy away from them. I don't do them.
But they theoretically, if they were a new association and the power of sale provision existed in their governing documents, they could do a non-judicial. Would that be fair to say or not fair to say?
I would just footnote it. I would say the use of a non-judicial foreclosure remedy is vulnerable to challenge because there are people interested in challenging it, regardless of circumstances. So, yes, I agree with you that under the current law, there is room to amend project documents to say, okay, we have a power of sale. How that will be treated in the courts remains to be seen.
Well, just briefly, to complete a non-judicial versus a judicial foreclosure, about how much difference in time length is there between, if you, just in theory, between doing a non-judicial to completion versus a judicial?
Well, I hate to say months to years, but in the run of cases, it could be that significant. The non-judicial foreclosure process is intended to be a much more truncated process. It does involve due process, giving notice to the owners that they are delinquent and what the demand is. In the 2012 legislation, there is much more opportunity for the owner to engage the association with payment plans and other remedies. And the issue with the courts is really getting on the docket and moving through the process. But if you have a court judgment, that has value.
So I will give you my standard answer that the association should check with their attorney when they have a delinquency and what to do next.
I agree that.
So, okay, we're at the end of our show. Do you have any last words about what we might see happening in 2021? And in brief terms, I know you mentioned maybe another foreclosure bill to clean up some of the problems that have been created by the recent ruling, but you see anything else coming down the road you think might be valuable?
Well, I think it would be valuable for the legislature to consider the authorities of associations to conduct meetings and other business, given our experience with COVID-19. Some additional authorities may be appropriate to address what do you do and how do you keep functioning when the world is in the middle of a pandemic.
As I said, that I always wish I'd bought stock in Zoom and the plexiglass companies. Because I think that's where all the, I think they've probably done pretty well. I actually read an article about Zoom. They've done over the top success and with their program. So on that note, I want to thank you for being a part of our show today, and certainly your service to the industry on the CAI LAC as the chair. I know you've done that for, I think it's a lifetime job the last time I read, but actually you have term limits of 10 years, so you have a while to go yet. But I want to thank you for being on the show today, and want to say stay safe. I want to say to all of our viewers, we appreciate you watching Condo Insider. We hope you've learned something today about what happened in the 2020 legislature, and we hope you can join us for next week's show, Thursday, 3 o'clock, Condo Insider. Aloha, stay safe.